right, good morning, everybody. Will you go ahead and call the meeting to order? First order of business is to have the public disclaimer and the roll call given to the record today.
Thank you. Notice of the September meeting, of the October meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since September 15th, 2023. Additionally, this month's agenda has been posted on the website since Wednesday, October 9th, 2024. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet or by placing their name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for other speakers. I will now call the roll. Chair Diaz.
Here.
Vice Chair Ferris.
Here.
Commissioner Moffitt.
Here.
Commissioner Begley.
Here.
Commissioner Torbett.
Here.
Commissioner Glenn.
Here.
Commissioner Smith.
Here.
Commissioner Tucker.
Here.
Commissioner Gahn. Thank you. I also want to acknowledge the attendees that are attending the meeting in East Tennessee. If you would like CE for attending the meeting today, please be sure to sign in. It will be required that you stay for the duration of the meeting and sign out at the end of the meeting, and you will be awarded CE hours for attending today. Also, commissioners, the mics are very, very hot, so please be mindful, and we're going to share mics, so please be mindful and pass the mic to other commissioners as they would like to speak. Chair Diaz.
All right, next item is to do our prayer and pledge. Commissioner Ferris will lead us in both.
Thank you, Chairman. Let's pray. Dear Lord, thank you for this day that you have made. We come before you now and give you our time. We ask you to come into this place and to guide our thoughts and our words and our actions. We thank you, Lord, for the state of Tennessee and for our home. Thank you for everybody that is in this room today, their stories. Please be with each of us as we are here and as we depart. Please be with all of our friends and family nearby in Tennessee and in North Carolina who have lost so much and have truly had their worlds upended. We ask that you come into these communities with a special presence of peace and restoration. We lift all these people up to you, Lord. Thank you again for this day. It's in your Son's name we pray. Amen.
Amen. Thank you, Commissioner Ferris. Next item is the approval of the agenda. Are there any amendments to the agenda? Hearing none, is there a motion?
Move to approve.
Second.
I have a motion to approve by Commissioner Wynn, seconded by Commissioner Tucker. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Next is approval of the minutes. Are there any changes to the minutes? Hearing none, is there a motion?
Second.
I have a motion to approve by Commissioner Torbett. Is there a second?
Second.
Seconded by Commissioner Tucker. All those in favor, please say aye.
Aye.
All those opposed? Hearing none, that motion carries unanimously. Ms. Baker, we got any formal appearances? Do you want to do a roll call?
Yes, for those here for informal appearances that are on the screen, please turn your camera on. I'm going to call the roll for those with us for informal appearances. Stacy Galusi, are you here with your broker, Janice Duncan? Okay. Justin Rhymes, are you here with your broker, Rebecca Hamby? Justin, are you able to unmute your mic? Oh. Let me, hold on just one moment, please. able to hear us? Justin, Kurt, Amir, is anyone able to hear us? Hello? Are you all able to hear me? Okay, one moment. Denny, if you would turn that down. Okay, I'm gonna call the roll again. For informal appearances, Stacy DeLucy, are you here with your broker Janice Duncan? Stacy DeLucy, if you could unmute your mic, are you here with your broker Janice Duncan? Okay, Justin Rhymes, are you here with your broker Rebecca Hamby?
I can't really understand.
Are you here with your broker Rebecca?
Yes.
Okay, great. And Amir Nasheed, are you here with your broker or your intended broker, Kurt Steckel? Okay, great. We're gonna begin with Justin Rhymes. Chair Diaz? Yes, sorry. Justin Rhymes is seeking an affiliate broker license and has taken and passed the national and state exams. He is before us today due to a felony for manufacturing, delivering, and selling a controlled substance. His statement and letter of recommendation can be found on your iPad.
Thank you, Ms. Baker. So the way these informal appearances go is the applicant will be given the opportunity to speak to us and describe the circumstances that bring them before us today. Commissioners will have an opportunity to ask questions, and then their prospective broker will be able to give a brief statement as well, and questions will also be asked. After all that, there will be a motion for the disposition of the application, and then we'll vote. So Justin, if you want to go ahead and describe the circumstances that bring you before us today, we'll go ahead and get started. Mr. Rhymes?
Mic should be on.
Justin, are you able to hear us? All right, did you hear Chair Diaz's statement? You did not hear Chair Diaz? Okay, Chair Diaz requested that you give an account of why you have a felony on your record, and then once you speak, your intended broker will speak, and then a decision will be rendered whether or not to grant you a license for real estate here in the state of Tennessee. We can hear you, so if you could speak a little bit louder, that would be great. Okay, go ahead, sir. Hold on just a second, Justin. And everyone here, we apologize whenever we take our meetings on the road. Sometimes there's some technical issues, so just a moment, please. Also want to acknowledge that Commissioner Gahn has been seated. One moment. All right, Justin.
There we go. I can hear you great.
Okay. Go ahead.
I don't know what you need from me. I could barely understand you at all earlier.
Okay, so we need from you to give an account as to why you have a felony on your record, and then your broker will speak and attest to your you working or your intent to work for that broker, and then the commission members will decide if you are to be given a real estate license here in the state of Tennessee.
Okay. That's a pretty simple one. I was fairly young. I was going to school, and at the time it was electrical school. I didn't really know where I wanted to be career-wise, but that was a good place for me to be. I had a friend who needed an apartment to stay. I had one. Essentially, he sold marijuana out of the apartment, and because because the apartment was in my name, I got charged as well. I knew what was going on. I didn't have a problem with it, and it got me through school. But it didn't take long, you know, after I got arrested and stuff to figure out that's really bad behavior. And you can't just let people do illegal activities around you. You know, you have to separate yourself from that. So essentially, I made some mistakes, and I was really young. Now I'm 32. That's definitely in my past. And to be fair, I've been an electrical technician. I've even got promoted and stuff. I wanted to change careers. I didn't necessarily want to stay doing that, though I could. And I gave up a $100,000 a year job to try and do this. So whatever it takes, I'm in.
Thank you for your comments. And your intended broker? You're muted. Ms. Hamby, you're muted.
Can you hear me?
Yes.
Okay, sorry. So I met Dustin. He is very interested in being an agent. After speaking with him and everything about his past and stuff like that, I do understand people do make mistakes. So we are willing to give him a chance with our brokerage. We think he'll do very well. He's committed on doing all of the training that we require of him throughout our offices in Knoxville. He's going to sign up with our coach so he can hit the ground running once he starts. And he's going to have active engagement with our brokerage, the activities, compliance, everything. He will be closely supervised, probably for the next 3 to 6 months, if not longer. It just depends on what you guys require from us. But he will be checked in on regularly as well after those 3 to 6 months.
Okay, so I'm going to give it to the commission to deliberate, but we're going to pause just for a moment so we can get our sound working right. Just one moment, please.
Thank you.
All right, Commissioners, any questions for this?
Just a moment so we can get this down.
Mr. Baker, we're gonna have to use the volume on this line for connection.
Is that accurate?
On the touch screen, unmute.
Okay. All right, we're ready for you all to deliberate. I'm sorry for the technical difficulties.
Apparently, Joe Monty has joined us. Sorry for all this technical issues, Mr. Rounds and Ms. Hamby, but Commissioners, is there any questions for the candidate or for Ms. Hamby? Hearing none, is there a motion?
Move to approve.
Second.
I have a motion that was approved by Commissioner Ferris, seconded by Commissioner Corbin. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, the motion carries unanimously. Congratulations, Mr. Rounds, and good luck.
Thanks very much.
Thank you all so much.
It was muted, but that was our yes.
Do we need to stay on the entire call?
No, you're free to stay if you want, or you can go about your day.
Okay, perfect. Thank y'all so much.
Thank you.
Take care.
Justin, I'll talk to you soon.
Hopefully.
Okay, next we have candidate C, Amir Nasheed, with his intended principal broker, Kurt Steckel. Mr. Nasheed is seeking an affiliate broker's license and has taken and passed the national and state exams. He is before us today due to a violation of probation order. His statement and letter of recommendation can be found on your iPads. Mr. Chair, if you want to go through what you said earlier,
Sure.
without making anyone confused.
Okay, so if you observed how Mr. Rhymes' application was handled, both he and his principal broker were allowed to make brief statements about the reasons for being before us today and why the principal broker would like them to join their firm. And then the commissioners will be given an opportunity to ask questions of either or both of the speakers, and then we will vote, and that's how it will go. So Mr. DeShee, if you're prepared, go ahead and just give us a brief story about what brings you before us today.
Yes, right before Corona, me and my wife, we started a small restaurant business. Then the Corona hit, we shut down the spot, then we start renting it for like special small party, like birthday parties and stuff like that. And one of the party, they were serving alcohol without our permission, but they got busted. At the end of the day, we are responsible for the business. This is how we got in trouble for it. And then when I moved, I didn't update my address with they put that place for in prohibition for like 1 year. We will start trying to sell the place before that, but we couldn't. And I ended up violating the prohibition and getting in trouble. This is not me as a person with no mistakes. I always like to educate myself, that's why I applied for the real estate license. I'm a big member of David Church. I do a lot of community service, so I always try to lead by example from my kids. That's why I think I will do good on it.
Thank you. Mr. Steckel, please go ahead.
Yes. Based on my conversation with Amir, probably over the last 25 to 60 days, I feel very comfortable based on what happened in 2021, the mistake that was made, and his intention of moving forward into real estate. And he's already plugged into all of our training programs. We've been involved with the mentor program, so we've been overseeing his production moving forward. So I feel very comfortable with him joining our firm in Franklin at this point.
Thank you, sir. Commissioners, any questions for Mr. Nishin or Mr. Steckel? Hearing none, is there a motion? I have a motion to approve by Commissioner Smith, seconded by
Second.
Commissioner Moffett. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations, Mr. Nishin, and good luck.
Thank you so much. I appreciate it.
Thank you all.
Ms.
Thank
Baker,
you.
Thank you.
is candidate A with us?
Yes, candidate A, Ms. Galuzzi, is your intended broker Janice Duncan with us today?
They're going to be here at 8:30. I had sent the information over to Dennis because they had a scheduling conflict with, and they just couldn't log on until 8:30. I said as long as I log on and held the spot, they could join as soon as they got available.
That's fine. We'll do waiver requests. And when your intended broker is on, if you would type that in the chat, and then we will proceed with your informal appearance. Does that work for you?
Yes, absolutely. Thank you so much.
All right, very
All
good.
right. Ms. Baker, tell us about Shirley Lombard.
Okay, our first waiver request is for Shirley Lombard. Ms. Lombard is seeking a medical waiver extension for continuing education and relief for her late fees. Her license expired June 11th, 2024. I should note that she was assessed an additional $50 fee on October 10th and will be assessed an additional $100 every 30 days as of November 10th, 2024. Her statement and doctor's note can be found on your iPad.
So I see her medical records. I don't see a note specifically from the doctor in here. Is that the medical record you speak of?
Yes.
Commissioners, any discussion about this waiver request? So again, you said she's seeking relief from,
From her continuing education as well as her late fees.
okay. So she got a broker license that's expired right now, so was never retired, never
Correct,
surrendered.
correct.
she's not a grandfather, she got 2020, so. Commissioners, any thoughts?
If you look on page 4, there is a small narrative of her medical situation.
How many hours was she lacking? All of it?
Yes,
So if we waive the hours, the CE, and waive the fine, her license becomes active?
yes. Once she pays a renewal fee.
Okay.
What is she asking?
Well, she's asking for an extension, excuse me, she's asking for an extension of her CE.
She
She has,
should still complete the CE.
Yes.
And basically just wants relief from the late fees.
correct.
So it seems to be some kind of motion where there's a clock ticking for her to finish her CEs,
Yes,
and then waive the fee would probably be
What is the fee right now?
balanced.
her fee right now is $300, and then she'll be assessed an additional $100 on November 10th.
Is that statutory? Do we have relief to,
The commission has discretion.
so we can lock it in at 300 because she did apply? So
Yes.
we could stop the fee, put a clock on it, and if she finishes her CE, we can wipe it away.
Yes,
But it has to be done within a period of time.
Clock's ticking.
How many hours of CE does she need?
16.
If she, how long do you have from her license expired in June of 24? How long does she have to get it done? and get it?
2 years. So she should have had her, she had between 2022 and 2020.
I mean, afterwards, if it expires, do you have a 30-day grace period or 60?
No,
No grace.
no. We won't renew your license if you don't have your continuing education.
I understand that, but what if I had it 2 days after my expiration? Would you?
You would pay a $50 late fee and your renewal fee, and you would be in compliance
Right,
with.
so at this point, 4 months passed.
Mhm.
Is it just, she can still do that and pay the fine?
Yes,
So she's not really asking for an extension.
well, she hasn't,
Shouldn't need an extension.
she's asking for an extension of her continuing education credits. And then she also wants you all to waive the fee as well.
Right now, her license is expired,
Her license is in expired status,
so she can't work.
correct?
But if we don't do an extension, she takes this 16 hours, pays $300 by November 10th, she's good.
Yes,
We can waive one and not the other, correct? Or wrong? Or can we give her the extension on the education, but
Correct.
not waive the $300 fee?
you could do that as well.
But do we have to freeze it at $300, or is it gonna keep adding up until that?
So the first 120 days, it's $50 per 30-day period. And then after 120 days, it's $100 per 30-day period.
But we could freeze the 300 as long as it was taken care of by the end of November.
Correct.
Floor is open for a motion, Commissioners.
Move to give this,
Ms. Lombard.
Ms. Lombard the end of November to complete her CE and waive the $300 late fee.
Second.
So we have a motion to freeze the fee at $300.
To waive it.
To waive the fee at $300 and allow Ms. Lombard to, till the end of November of 2024 to finish her CE. It was made by Commissioner Ferris, seconded by Commissioner Corbett. Any further discussion? Hearing none, ready to vote. All those in favor of the motion, please say aye.
Aye.
Any opposed?
No.
You will vote?
Can we do a roll call vote?
A roll call vote, Ms. Baker.
Commissioner Boyd,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Smith,
No,
Vice Chair Ferris,
Yes.
Chair Diaz,
I'll go last.
okay. Commissioner Corbett,
Yes.
Commissioner Begley,
No.
Commissioner Tucker,
No.
Commissioner Brown,
Yes.
This is 3-3.
I think it's 4-4.
4-4.
No,
No, it's 5-3.
Ayes have it.
Excuse me, 4-3, wait. The ayes have it. Okay. I apologize.
Give it a count again. 5-3. 5-3.
Yes. And how are you voting?
So the vote on the motion is 6 ayes, 3 noes. The motion carries by a 6-3 vote.
Thank you.
Next is Ms. Marilyn and Duarte. Ms. Baker.
All right. I should note that Ms. Eduarte has changed her last name, so you will see a reference to Cruz in her documents. She retired her license, her retired license expired May 11th, 2024. She would like a medical waiver for the late fee and CE requirement. I should note that she will be assessed $100 every 30 days as of November 10th, 2024. Her statement can be found on your iPads.
So, just so the timeline of this is, she retired her license at some point.
Yes, her license was in retirement when it expired.
And then she had her medical issues
Yes,
and license expired.
yes,
So the status of that license is expired.
yes.
Okay. And she's coming to us now, I guess she's through her medical issues, and she wants to unretire the license or just,
She wants to keep her license in retirement, however, she does not want to pay the full late fee. And she's requesting relief from the late fee.
What's the late fee?
and she's at $400 right now?
That is correct. The late fee is $400.
Is the late fee different calculation if your license is retired versus not?
The first,
Cheaper, in other words?
the first, no, there is not a difference. The first 120 days, it's $50 per 30-day period, and then thereafter, it's $100 per 30-day period.
What about the fee itself? Same for the,
Yes, it's the same for retired licensees as well as active licensees.
I'll make a motion to approve.
Second.
What are we?
We are approving the waiver, waiving the $400 fee.
Okay, thank you.
So the approval would mean that the fee goes away and her license goes back to retired status.
Okay,
And then she, is that, it's more of a question than a statement.
okay,
Was it so $4 goes away?
yes.
Her license is in retired
Once she
status?
pays the renewal fee of $75, yes.
Renewal fee, okay.
Okay. But she's also seeking an extension for CEs.
If her license remains in retired status, she's not required to seek or have CE.
Okay. And that $400 would be paid by a certain date?
Well,
Well,
we're not to waive it, or the motion is to waive
Right,
it.
okay.
I have a question, just based on what she's wrote here, she did some sort of CE.
Some licensees in retirement still take CE, although they're not required to do so.
Remind me, are they counted if they don't, are they logged somewhere in our system? If they
In
like-
CE broker,
Yeah,
yes,
so they get, there's credit there, but they don't have to do it.
correct.
Okay.
All right, so just to restate the motion, Commissioner Smith made a motion to waive the $400 fee, was seconded by Commissioner Ferris. Any further discussion on the motion? Hearing none, let's go ahead and vote. All those in favor of the motion say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Any other waiver requests?
That is our last waiver request.
Next item on the agenda is the education report.
All right,
Ms.
thank you.
Baker.
As you all know, Ross White retired from state service. His last day was on October 11th. The Department of Commerce and Insurance has been expeditious in posting the TREC Education Director position. The position was posted on Tuesday, October 15th. It will close on Monday, October 21st. Upon review by HR of the slate of candidates, I will conduct 2 rounds of interviews. The first round will be a virtual interview with me and a member of the TDCI HR department. The second round interview will be with myself and Assistant Commissioner Reed Witcher. We hope to have a new Director of Education enrolled by the end of the year. Are there any questions in reference to the vacancy? All right. You will, well, before I get there, Notices for course renewals and instructors have been mailed out to all instructors and providers for for our education courses, for those folks to teach in 25 and 26. So far, we have about 100 and some odd instructors that have renewed, and we're in the process of renewing courses as well. And next month, you will be presented with new track 4 courses for approval as well. Actually, today as well, we have a few today that are in the package. Are there any questions about renewals for instructors and or courses? All right, you will notice in front of you today, we had to print a new slate of classes for approval. We added class 37, that's the only difference from what you guys were emailed earlier. This month, you will see class 37. Now, we only have 4 copies, so it's the last class from the Tennessee Appraisers. So we did add that class as a 7-hour course. And so I would like to introduce or submit to you all to approve 37 real estate classes for approval.
So we have courses 01 to 037 that are submitted for our approval. Are there any courses commissioners would like to pull to discuss further? Hearing none, is there a motion?
Motion approved.
Second.
I have a motion by Commissioner Ferris, seconded by Commissioner Bagley to approve courses 01 through 037. All commissioners in favor, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. I think you have 3 instructors for us today.
Yes, I would like to submit 3 new instructors for your approval. Their resumes and qualifications are on your iPads.
Commissioners, any questions about these instructor applications? Hearing none, is there a motion?
Move to approve.
I have a motion to approve by Commissioner Ferris, seconded by Commissioner Smith. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Any more in the education report?
Now, unless you all have questions, I believe Commissioner Begley may have a
I
question.
just had a question. So usually Ross vets these folks, right?
Yes, he did this month as well.
Vet these.
Yes, and I'll be doing it in the month of November as well as December.
Now, Commissioner Baker, you're up again with the executive director report.
All right. If you were to refer to your iPad, you'll see our numbers for the month of October, and I do have a few announcements. First, I want to begin by thanking members of NETAR for their hospitality in helping us arrange for our meeting here in East Tennessee today. I especially want to thank Ms. Ann for all her assistance in helping us organize this meeting today. So if we could give her a round of applause. And Diane, you have your phone up here if you're looking for it. All right. First, I would like to begin with the Arello Conference. As a part of the Arello Conference, Chair Diaz and I attended Commissioners College 101. We confirmed that Tennessee is conducting commission matters in a proper fashion. The conference had many speakers giving presentations on the subjects of the NAR settlement. Would you like to make any comment in reference to the Arello Conference in Chicago last month?
The only thing that I would like to add is that the Commissioner College 101 did touch on the NAR settlement as well, and clarified a lot of things for me. In particular, the presenters in that course talked about how, you know, even though there's been a lot of turbulence in practitioners about the settlements in NAR, the settlement doesn't change any of the laws that were in effect before the settlement. So the antitrust laws that were valid the day before the settlement are valid today. And while it's an adjustment in how we're going to conduct our business, it might not be, the growing pains might be a little stressful to go through, but it's not going to be, at least I felt that it's not going to be as disruptive as I thought it was going to be. So I got a lot of comfort out of that as a practitioner, and I hope all of you will be able to navigate it well and feel comfortable to continue to practice real estate. As far as the presentations go and things like that, I think they were very informative. And some of the, I guess we call them subject matter experts that they presented, they had some interesting opinions. I can't relay them to you today, I won't do that, but all in all, a great conference, and I look forward to the next Arello conference and see what they do next.
Very good, thank you. Tennessee Realtors would like to have a track panel during the TN Next Summit in February of 2025. It will be at 2 o'clock on February 11th, which is the day of our commission meeting in February. They said they will work hard to provide a larger space for the panel discussions instead of standing room only last year. Additional details will be given in the months to come. Will you all be available, or some of you all to be? Okay, great. I will confirm that with the folks at Tennessee Builders. Are there any questions about?
What time again?
2 o'clock.
I'll go around 2 o'clock, but I'll have more details in the coming months. Can't believe we're talking about 2025 already.
Yes.
All right, next, Rice was selected to be our state of Tennessee provider for E&O insurance this year. The term will be 18 months for $165. Rice can provide optional coverage for appraisal activity of real estate brokers or affiliate brokers who are licensed real estate appraisers. And that policy will be an additional $38 for appraisal coverage. This contract can be renewed upon satisfactory completion of the term. The state reserves the right to execute 2 12-month renewal options under the same conditions as the state's sole option. In the event that we were to extend the contract, the total amount of months that Rice will be covered or will be able to provide licensees with the state of Tennessee policy is 42 months. As of October 8th of this year, approximately 37,000 licensees use Rice Insurance. TREC employees were gearing up for a robust E&O renewal year. We will be announcing this information in a TREC newsletter on or around October 26th. And if you guys could go to your brokerage and encourage those folks to go ahead and sign up for E&O insurance sooner rather than later. December is always a difficult month for us, with not only the holidays, but with the renewals of E&O insurance and instructors and providers. It can be very difficult for us, so if you can encourage your folks and anyone who will listen to you all to go ahead and sign up for E&O insurance and become compliant before the deadline of January 1st. For those that are covered by Rice, I would greatly appreciate that. Any questions in reference to E&O insurance? Next, we have the Arello Regulatory Investigation Seminar. Kim, Ariel, and I will be attending the Arello seminar next week in Ohio. The seminar will offer a great opportunity to learn and exchange information and ideas with colleagues about topics of special interest to member jurisdiction. Extensive case law litigation and investigation techniques will be presented to us. There is a lot going on, as you guys know, currently in our industry, especially with deregulation and demanding real estate markets. It will be very beneficial to get ahead of what other jurisdictions are seeing and how they are responding to the changing climates pertaining to investigation. So we're looking forward to spending some time with Arello again next week. Are there any questions in reference to that? Next, I would like to announce that we are now members of the Real Estate Education Association, and we are posting our position that we have vacant open there as well. And that concludes my report. I will be more than happy to answer any questions that you guys may have.
Commissioners, any questions for Ms. Baker?
Have there been some applicants for the new education director position?
Yes.
Great.
Hearing none, thank you very much, Ms. Baker. All right, so this is the public comment period. Is anybody signed up to speak or wishes to speak?
Would anyone like to speak for public comment? We are good to go.
All right, so the public comment period is closed. Commissioners, do we want to take a recess?
Before we do that, can I check back in with Stacy Galusi? I don't believe her broker Janice is on yet, so.
Okay.
Can you hear me?
Yes.
Can you guys hear me?
Yes.
There we go, okay. No, they're not logged on yet, they said 8:30,
Oh, okay, sorry, we're on Eastern time, so I'm a little off, so please forgive me. All right, we'll try you again in about 20 minutes.
okay, thank
Thank
you,
you.
I appreciate it.
Okay. So recess,
Yes.
commissioners? All right, so we'll do a 10-minute recess. We'll reconvene. Let's go ahead and call it, we'll just say 9:22.
Thank you.
Thank you. We're in recess.
Oh, it's your phone.
Whenever I would message her and get my tattoos, it was like, I'm on do not forget me
Hey girl, how are you? Hey, hi.
Everybody, we're about to come back to order.
Yes, sir, I am.
Everybody's ready?
Yes.
Very good. So the next item on the agenda, are we gonna try to do Ms. Galuzzi? You want to try?
It is not 8:30 yet, because, her intended broker is on Central Time, I believe there's some, shuttling of children to school, so that's why they requested 8:30.
Okay, so we'll go ahead and get into the legal and consent agenda.
Denny, please mute.
So, on the legal report, the commissioners have pulled the following cases. Case 1, 2, and 3, 5, 8, 11, 14, 19, 26, 29 and 30, 31, 34, 42, 44, and 52. Are there other cases commissioners wish to pull?
56.
Case number 56, pulled by Commissioner Gwynn. Any other cases? Hearing none, is there a motion?
So moved.
Okay, so we have a motion to accept council's recommendation on all cases on the legal and consent agenda, minus the cases just read into the record. Motion by Commissioner Torben, seconded by Commissioner Gwen. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, so ordered. Case 1 was a discuss. Council,
Yes, sir.
what do you want to tell us about this case?
The background in this case is that there was a tenant signed to a lease agreement with the property manager. The parties to the lease were the tenant and the respondent. The complainant was the owner of the property. The term of the agency agreement between the complainant and respondent to manage that property expired on April 30th of 2024. The complainant notified the respondent in February of 2024 that they would not be renewing their contract for property management. The lease expired at the end of May in 2024. So the respondent went ahead and notified the tenants that because their ability to act as the landlord ended on April 30th, that therefore their lease was going to be terminated on April 30th. The respondent did that without notifying the complainant, which is the heart of the agreement here. There's a month there where the tenants being notified that their lease was up, went ahead, put a non-refundable deposit on another property, all without the complainant realizing that they were moving out because the complainant intended to re-sign either those same tenants, would have been preferable, or to, if they were going to leave at the end of their lease, would find new tenants. So the heart of the complaint there was that the respondent moved forward and terminated this lease during the agency agreement when they were still supposed to be acting as their agent, without notifying the complainant of that termination.
And so, I mean, so you don't think it's just a contract dispute you want us to?
My concern was that the complainant did make attempts to get information from the respondent while they were still under this agency agreement, and the respondent did not respond to those requests.
Right, the respondent was saying that they were not a party to the agreement, so they didn't have some notice requirement?
Correct.
That's the part I didn't understand, how the complainant wasn't part of that.
So, I mean, I can see that the lease is between the tenant and the property manager acting as the agent, but I can't see how the complainant is not notified of the owner of the property. I don't understand that aspect of it. I know if I were a property owner, I would want my property manager to keep me in the loop. That'd be something I'd want to know, especially if you're terminating the lease.
That was my concern as well. The complainant actually ended up having to go to the home and saying, hey, I'm the owner of the property.
Right.
I think the lease is between the owner and the tenant. That's what I think. I think
what
this
it should be,
person got
right?
mad because they were losing their management and they
The
spiked.
respondent should have an agreement with the owner about managing the property, but the lease should be between the owner and the tenant.
I know, Mike, I was thinking, am I crazy reading this?
Yeah.
How's the complainant harmed?
Plus tenant.
Lost a
No.
month rent. Lost a month rent, potentially more if the tenant would have stayed.
The complainant is the property manager, right?
Owner.
No, the complainant is the owner of the home. They signed an agency agreement with the respondent to act as the property manager, and then the property manager respondent entered into a lease agreement, and I looked at the lease agreement, and it does say the parties to the agreement are the property manager and as agent or owner, and the tenants.
Did you get a copy of the agreement between the owner and the property manager?
I believe that the complainant provided that.
If you just look at this from a different direction, say, I leased a commercial building or something for 5 years, and then I decided to move to Alaska next week. Do they cancel that lease because I left? Or, you know what I'm saying? I think the lease is the lease. Even if you sell the property, the lease stays.
Right, unless otherwise dictated by both the parties.
Well, and I think that's why our sentiment seems to be that the lease should have been between the tenant and the property owner, and not the tenant and the property manager.
Unless he has the right in his property management to do so.
Right.
My computer is frozen, so just give me a moment to see.
Must be the mountain air.
It must be.
Does anybody have any ideas of how they would want to make a motion on it?
Well, I mean, it depends. I mean, if the property manager did what they had the right to do under their agreement, then I don't see a violation. But if they deviated from their agreement, then
So we can still look in that, telling the owner that he was stopping the lease.
Yeah, no
So-
communication is a big deal.
so I dug through the rules, which was fun. And I have sympathy for our legal counsel.
close.
But this end of the table,
You did go until the practice is on, so reading laws is your job.
the mic's down to the line.
Well, I just say 1260.03-.06 is where I landed.
For it to be like that, they'd have to give them full power of attorney over that property, right?
Do we know if the complainant received lease payments?
From the property manager, yes.
They did.
They funneled through the respondent.
Again, I'm scrolling very slowly through the documents here.
Does this complainant have other properties under management with this respondent?
Not to my knowledge, no, sir.
So the respondent does not address their refusal to provide the contact information or their failure to notify the complainant. And I think that's a big deal.
Right. Agreed. I mean, that's what the complaint has here in front of us. I don't know that we have to leave. I mean, that's what the complainant is complaining about, the fact that they couldn't get the information once they requested it and didn't have any communication. Mike, is it safe to presume that the complainant has got an understanding that that's how it was all supposed to be done, that it would flow through the respondent? And they're not making that complaint.
Right, it could be.
I don't need to assume that just because I think it's weird, it's wrong.
Right.
If they've agreed to it,
Well, there's also 6213-4034, which is dealing honestly and fairly with all parties. When you can, doesn't, for me, it's not a hard call to say, well, this is kind of unfair. I mean, what's gonna happen with your property management agreement is gonna happen. The property owner made a decision not to continue your service, but you shouldn't burden the place down on the way out. You know, they may not like that you got fired, but, you know,
right.
that's life.
I'll make a motion,
Go ahead, Commissioner Gwynn.
to dismiss.
I have a motion to dismiss. Is there a second? Second. Seconded by Commissioner Moffitt. So a motion by Commissioner Gwynn to dismiss, seconded by Commissioner Moffitt. Any further discussion, Commissioner? Hearing none, let's vote on the motion. All those in favor of the motion say aye.
Aye.
Any opposed?
No.
No.
Opinion chair, the noes have it. Is there any dispute with the motion?
Thank you for your motion.
So we clearly feel like there's some offer has to be made here to this respondent. Commissioners, is there another motion?
I want to make a motion, but I'm back to your initial thing, Jeff, is just that this is almost like a civil contract dispute, not, I mean, it's not really, I don't know if it's us, is it?
There could be I'm thinking about how to formulate this motion, but there could be a motion made for a letter of warning, exercise reasonable skill and care, period. And yes, I agree with that too, Joe, that it's, plaintiff may have a claim elsewhere.
So I guess the way I look at it, it's the complainant, it's their fault, meaning, have we seen the management agreement?
I was finally able to pull it
I
up,
can't
yes.
believe that somebody signed an agreement that lets a property manager obligate them on a lease, meaning with no control, with no parameters. In other words, the way I read this is that the property manager signed the lease as if they were the landlord,
Correct.
which I find hard to believe.
Well, he states in there that he didn't have the information because he wasn't part of the contract.
So is the complainant and respondent both in Tennessee, or is the property owner out of state?
They're all in Tennessee.
They're all in Tennessee.
Yes.
Okay, so
And the management agreement gave the agent the power to rent, lease, operate, and manage the properties known as. So that answers your question, Commissioner.
So-
So the property owner did give them that authority. They would get that authority.
So they could rent it for $1, and it doesn't say anything about what they could rent it for, or they could spend money on, or anything else.
I just want to be clear, I'm not the one who wrote this. It does seem to give them a lot of authority, yes.
It's a complainant's problem that they got themselves into that predicament.
Yeah,
I would
if
agree.
that's true, I mean, if that's true, I agree with Steve. And it's hard to believe.
If that complaint is signed, anything,
So we just defeated quite resignedly a motion to dismiss.
I'll make a motion, we dismiss.
So we have another.
Second.
Second.
So motion by Commissioner Gahn to dismiss, seconded by Commissioner Nguyen to dismiss yet again. Commissioners, any further discussion?
Well, I have just a question.
Go ahead.
So in here, it says respondent asserts it was complainant who terminated the tenant's lease prematurely and acted against the interests of the parties. But I don't find that to be true based on what we have here. Because the complainant, unless I'm reading this wrong, the complainant just said they were terminating their agreement with the respondent.
To
Or
me,
they
I
were
mean,
gonna renew the lease without the respondent's involvement. So the complainant didn't terminate the lease, but the respondent says they did.
They're saying they effectively did by ending their agency agreement early, a month early.
that sounds like an issue for a judge or a jury to make. Who did what?
And I would not disagree with that. My only concern and the reason that I wanted the commission to address it was the lack of response to the complainant's request for information, contact information for the tenant so that they could move forward after the agency agreement with the respondent was over.
But he stated that because the lease was between the management company and the tenant, that he didn't have to give them that.
Well, they didn't address that at all, the lack of response. They just said they moved forward under their authority given to them under their property management.
Which either they had or they didn't have, which we don't know.
And my concern is with the tenant. The tenant got
Tenant's like, I just want to live someplace.
evicted basically for no reason and then had nowhere to stay.
Yeah.
I mean, in reality, the tenant here was the victim of all of this back and forth because they put down a non-refundable deposit on another place to live because as far as they knew, they were being evicted at the end of April.
They
So-
stayed in the property.
There's a motion, right?
There is a motion, we're starting to repeat ourselves, so if we're gonna repeat ourselves, let's just go ahead and vote. If you don't like it, vote no.
Well, let's wait one second.
Okay, go ahead.
So they stayed and just lost a deposit on a different property.
That's my understanding, yes.
You want to fine them, get the deposit?
Well, we have a motion to dismiss right now, so we need to either amend our motion or vote and try again.
Mike,
Mark made it, Steve said.
I'll take it from the name.
There's a,
does he have to
There's-
amend his motion or
Yeah,
does
he-
he
he
make a
says he-
substitute motion?
you can do a substitute motion or you can do a friendly amendment, yes.
I'll allow a friendly amendment.
DJ, you brought up a letter of warning before?
Stacy, do you have anything you want?
I would really like a civil penalty of some sort. If
Okay.
it could be reasonable skill and care.
I thought part 4 about dealing honestly and fairly with all parties, because that seemed to be more appropriate than reasonable skill and care. But
Okay,
Yeah.
$500 civil penalty for failure to deal fairly with all parties.
How much?
hold on, so you're offering a friendly amendment to the current motion. Instead of dismiss, you want to offer a $500 civil penalty for failure to deal honestly with all parties.
Second.
So that is second. So now that motion is currently under consideration. Did we do it right?
I don't think so.
Okay.
Since it was dismissed, can we
We
vote on
need,
that?
do we not need to vote on that?
Yes. We did.
Okay, so you prefer that we
What
just,
she said is not an amendment, it
It's a-
didn't sound like.
So can I just make a substitute motion before we vote that down?
Yeah.
Okay, substitute.
Now, let's vote, let's vote.
so,
Let's vote to dismiss.
you want to
Let's
vote,
vote to dismiss again, and then we'll,
or do you want to withdraw your?
I'll withdraw my motion.
okay.
So the motion has been withdrawn. So we are no longer considering a dismissal of the case.
Do I have to repeat my new motion?
And if Commissioner Jordan will allow, I'll repeat the motion. So the motion that Ms. Morgan would like to make is the motion to assign a civil penalty of $500 under 62-1343, Part 4, failure to exercise reasonable skill and care. That was made by Commissioner Torben, seconded by Commissioner Bailey. That's not Part 4?
I tell you that court part is honestly a good thing. Reasonable skill and care is not.
I know.
So,
Part 4.
Okay, I'm just saying, you said reasonable skill.
Okay. So, did I repeat it correctly? Okay, so that motion is now under consideration. Is there any further discussion? Thank you.
I support this motion because the very last remark the council makes is respondent does not address their refusal to provide the contact information. This is key for my opinion, or their failure to notify the complainant that they were terminating tenant's lease. I recognize that the complainant may have gotten themselves into this questionable agreement. But if a property manager is going to cancel a lease on a property that I own with a tenant that is in the property, I want to know about it. And I think that's at least a $500 civil penalty.
But there's got to be a back and forth between the manager, in this case the broker, and the complainant, the landlord. I mean, the landlord can't operate a property just out in a vacuum. I mean,
It sounds like they did.
I mean, but they let themselves do that. They let themselves get into that position. They didn't have, maybe there's no reporting in their agreement, who knows? But it just,
Yeah. Perhaps.
Any further discussion? Hearing none, let's vote. Anybody need me to repeat the motion? Good. All those in favor of the motion, say aye.
Aye.
Any opposed?
yes.
So that motion carries on an 8 aye, 1 no vote. Commissioner Boyd voting no. Next case, case number 2. Joe, that was you.
No, I didn't.
No, that's me, I'm sorry. So, what stood out for me was the respondent's claim that the complaint could be retaliatory. Is that,
Correct.
I mean, it seems to me like they did a lot of work on this case. I mean, they claimed they did 60 showings, they got 10 offers, and we're not a contract twice. So it seems to me that the respondent did a lot of work and, you know, I mean, do we have anything in the record that, you know, assigned rejections or anything like that that was given by the respondent to you?
No, sir. The gist of the complaint, and it is a lengthy narrative there, but that the complainant was essentially unhappy with a lot of things that occurred, but it seems to me to be primarily a failure to communicate effectively. There were multiple opportunities, I think, where the respondent could have better explained to the complainant what was happening, but the reason I recommended the letter of warning is because I don't think that failure to communicate effectively rose to the level of a violation, but moving forward, perhaps they should have better guidelines or try to better understand where the complainant or their client is coming from and why they're asking the questions they're asking, perhaps.
All right, so that is your recommendation, it's just a letter of warning,
Yes, sir.
and that's reasonable skill and care?
Yes, sir.
Thank you, counsel. Commissioners, any recommendation or motion? I have a motion by Commissioner Tucker to accept council's recommendation. Is there a second?
Second.
Seconded by Commissioner Smith. Any further discussion? Hearing none. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, the motion carries unanimously. Case number 3. That was me also. So this seems to be, it's administratively open complaint. Your recommendation was a letter of warning. I just wanted to see what was the civil penalty or disposition of the case against the affiliate.
They were assessed 3 civil penalties of $500 each because there were 3 websites that this respondent did not view. 3 separate websites that, in my opinion, violated advertising rule regarding having your firm number and name on the website. This respondent stated that they had met with their affiliate, and the one that the affiliate showed them when they met, they asked for their opinion and help in crafting that website. The respondent did that, and again, did not see the 3 that the affiliate went ahead and did in addition to what they did see.
So the respondent saw a version of the advertisement, but not the final published version.
Correct.
Good. So council's recommendations for a letter of warning. Is there any motion?
Motion to approve council's recommendation.
I have a motion by Commissioner Torben to accept council's recommendation in case number 3. Is there a second? Seconded by Commissioner Smith. Any further discussion? Hearing none, all those in favor of the motion, say aye.
Aye.
Any opposed? No. That motion carries on an 8 aye, 1 no vote, Commissioner Bailey voting no. Case number 5, me also. Council's recommendation here is also for a letter of warning for reasonable skill and care. I mean, my notes aren't extensive on case number 5 specifically. I just wrote the civil penalty question mark, but as I'm reading it, I'm kind of coming off of that. So. You also quoted part 4 in 403.
Yes, sir.
My concern was the last sentence, maybe the last 2 sentences.
And that was my concern as well, Commissioner, is that the respondent at some point became aware that they were not receiving correct information and yet continued to rely, perhaps to everyone's detriment, on getting that information from the same person without going to the home and checking on it themselves to make sure that that was being done. I'm sorry?
I haven't proved it, though.
Correct.
Right, so you're relying on third parties still after initially, yeah.
You're not getting the full picture.
And I think that's why now that reminded me is why the civil penalties, I don't know if a letter of warning is enough there. And it would be again for the same 403, part 1, reasonable skill and care. I don't know about honestly and fairly. Once you hear that the repairs are done and then you learn that they weren't, I think at that point you need to personally follow up on it.
I thought so as well.
Commissioners? Opinion? Motions?
Make a motion, we do a civil penalty of $250.
Second. I have a motion by Commissioner Smith to assess a civil penalty under 6213 403 Part 1 of $250 by Commissioner Smith, seconded by Commissioner Moffitt. Any further discussion? Hearing none, let's vote. All those in favor of the motion say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Thank you, Commissioners. Case number 8 is a discuss.
Chair Diaz,
Ma'am?
may I interrupt? I believe Ms. Galucci's principal broker or intended principal broker has logged on. Ms. Galucci, is your intended principal broker, may I,
Yes.
Janice Duncan on? If you guys could turn on your camera so we can do your informal appearance, please. Ms. Galucci, can you please turn on your camera and your intended principal broker, Janice Duncan? Ms. Galucci? Hi, Ms. Duncan, we're just waiting for Stacy Galucci.
Yes, you can't hear nothing going. Audio on. You hear us now?
Yes, we can hear you. Is your intended, yes, are you able to hear me? Are you able to hear me? Are you able to hear me? Ms. Galucci or Ms. Duncan?
Sorry.
Yes, I'm here.
Okay, Stacy, can you turn on your phone, please? Or turn on your camera, please?
My camera's on.
We don't see you. Do you have a cover over it or something?
No. Should be.
All right, we're gonna proceed, if that's okay with Commission members. Chair Diaz, or Commissioners, Ms. Galucci is seeking an affiliate broker's license. She will need to retake the national and state exam as her exams have expired because it exceeded 6 months and she originally took her exams. She's before us today due to a revocation of a California real estate license. Her statement and letters of recommendation can be found on your iPad. Chair Diaz.
So her license was revoked because of not reporting to California about her convictions, or?
That was for Ms. Galucci.
Okay.
To say. Ms. Galucci, do you want to explain why your license was revoked in California?
Yes, my California broker's license was revoked because I failed to disclose a DUI within the 30-day time frame. I got the paperwork back to them, but it was like 37 days, so I was past their deadline. I was eligible for reinstatement after 1 year. I did not take that course because we were already planning on moving out of state. We didn't want to raise our children in California. We moved to Tennessee. We bought land, built a house. I homeschool my children. I also teach classes at our local Christian Family Co-op group and volunteer for the local 4-H organizations. We love it here, and our next step is selling our California rental properties and 1031 exchanging into Tennessee rental markets, which is why I wanted to get my license and be able to work in Tennessee.
Okay. Thank you very much. Sorry.
You're welcome.
Duncan.
Ms. Duncan, please tell us why you would like Ms. Galucci to join your firm.
I'm sorry, I didn't understand that.
Commissioners, do we have any questions for this candidate? None? Okay, I'd like to hear from the broker now. Ms. Duncan?
So my broker Peggy is on the lower screen. Seth, can you guys hear us?
Yes.
We can. Yeah, Peggy Malone. She's the principal broker.
Sorry. Okay, go ahead. Please tell us why you would like this candidate to join your firm.
We're having a hard time hearing you, to be honest with you. you hear that, Vic?
Yes.
Okay.
Since Stacy is moving to Tennessee, we'd love to welcome her to our firm and have her join us and work with us.
Thank you very much. Commissioners, any questions? Hearing none, is there a motion?
Move to approve.
Second.
I have a motion by Commissioner Ferris to approve this applicant, seconded by Commissioner Tucker. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations, Ms. Gazaluzzi, and good luck.
Congratulations.
Thank you so much. I really appreciate your guys' patience for all of this.
Thank you.
Thank you, Patty. You're welcome. That's an every board.
Do we have like an award we can give candidates for the most track meetings attended or something like that? So we'll go back to the legal and consent agenda. We were on case number 8, which was a discuss. Counsel, what is your instincts about this case?
Well, so the complainant was the seller of the property and the respondent was the agent for the buyer. The complainant essentially is alleging that the respondent misled their own agent about the successful financing of the buyer to their extreme detriment, because while they were under the impression and had been told via text message and by their agent on April 3rd that everything was, with the buyer's financing was good to go. And so they went ahead and made an offer with no financial contingency on another property. And come to find out, things were not good to go on behalf of the buyer. And the buyer, while their agent was telling the complainant that they were moving forward on the purchase of their home, were actually the respondent and the buyer were looking at other properties and made an offer and then purchased another home. So the complainant here, the seller, obviously was very upset. They lost their earnest money. They spent a lot of money in storage fees and moving out, only to come to find out just a few days before closing that that was not going to happen, and that perhaps the respondent knew that was not going to happen almost 3 weeks earlier.
So,
And, pardon me, go ahead.
I was going to say, I had to write out the timeline of this case because it just helped me visualize it. So when I got March 20th, the statement from the respondent is the loan is an underwriting. And then April 3rd, the loan from this initial financing option is apparently denied, but the buyer is looking for other financing. And this is something that the respondent is aware of at this point.
Correct.
Then on the 24th, the complainant, the buyer signed a backup offer on another property.
Correct.
Then on the 25th, the loan is what they categorize as fully denied.
Yes.
As opposed to partially denied. I guess that's an option now.
That's a new term to me as well.
But the closing itself was scheduled for May.
Correct, May 17th.
So I think there's, and I want to say that, agents are usually motivated to keep a transaction on track. And both the buyer and the seller side, they want, if there's some kind of hiccup with financing or some other reason why the deal might be in jeopardy, we tend to work very hard to kind of solve it. So being communicative and with both sides is very, very important. So I just don't understand why the respondent was told that information about the loan unless his client was telling him not to do it. But I don't understand that.
I was curious, the seller turns around and buys it and was not able to, back up. If I'm reading this correctly, the seller made an offer on another house. Is that correct?
Yes, ma'am.
And while
It's the same agent that was selling their property, represented them in buying, and trying to buy it next month.
But Felton put in there, 72, that house closed.
Yes, ma'am.
You're pretty sure there was no contingency?
Yes.
My only problem with it is, you know, date-wise, it was a month, it was almost a month out when they found out. The problem is the day before, agent took an offer on another house before you tell them they're out on that house. Have a little issue with that, big issue.
So again, you know, we rely on a reasonable skill and care or dealing honestly and in good faith. Seems to be the theme of the meeting.
And it does say that the buyer was approved with a different lender, it just was a higher rate, and they didn't want to go with that option.
They apparently had a relationship of some sort, business relationship with one of the lenders, and that's who they wanted to move forward with, and I guess they were the ones that finally fully denied the loan.
You were.
That deserves air quotes.
I'll make a motion to issue a $1,000 civil penalty to the respondent for lack of reasonable skill and care.
So we have a motion by Commissioner Ferris to issue a civil penalty for failing to exercise reasonable skill and care for $1,000. Seconded by Commissioner Smith. Yes. Any further discussion?
Yeah. So,
Commissioner Baker.
I mean, I agree with you, DJ, but also, who just brought up the contingencies? You know what I'm saying?
Yes.
You also want to give one to the other agent for, you know, no contingency on that close. I mean, you just can't pick everybody if they're aware. So that's almost, I mean.
Well, I think in that case, we can
We
talk.
have to open.
We have to open administrative open complaint.
We've never done that. I mean, not since I've been here. Have you, I mean, we've opened on brokers, but I don't remember like bringing in another.
If I may, the complainants know how to open a complaint clearly because they made a complaint against the respondent. If they wanted to make a complaint against their own agent, they are more than welcome to do so. I would hesitate to, based on what we're discussing today, for you all to administratively open a complaint.
We've never done that.
I don't believe so.
So, right, I'm ready to vote.
All right. Any further discussion? Hearing none, let's go ahead. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none. Motion carries unanimously. That was case number 8. Case number 11, that's me. So on this one, I just noted that the complaint is against the real estate firm, and not a specific licensee, like a broker or anything like that. Is that?
It's only against the firm. In this case, it may be appropriate to open against the principal broker, but I would defer to you all.
So, I mean, that was my only question about the case, is that it was against the firm and not the actual licensee that did the advertising.
I move to accept council's recommendation.
Second.
All right, so council's recommendation is to issue a $500 civil penalty, violating Rule 1260-05-06, Part 1, Clause B. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 14. All right, so this is the case of, you know, when you do no good deed goes unpunished. So this is the case of a good friend who put a for sale sign on a piece of property and their phone number for an out-of-town friend and they got dinged for an advertising violation or practicing without a license, was it?
Unlicensed activity.
Unlicensed activities.
Unlicensed activity, and, you know, they didn't receive compensation, they didn't do any of that, and, I don't know, it just seems like quite a hammer to throw down on somebody that they were doing a favor for a friend.
Was it a for sale by owners then?
It was just, my understanding, it just said for sale and their phone number.
This one hurt me as well, I will say. It just said for sale, and then it had the phone number. It did not have the respondent's name, just the phone number. I would suggest that if you wanted to lower the civil penalty to anything else, that would be all right as well, but it was an unfortunate act that may have large consequences.
Who was the complaint?
The complainant was a neighbor.
I just have a hard time, I mean, why would they put their own number if they did not negotiate this deal at all, or get paid for this deal, or talk about this deal? And when they call that number, what do they say? Just call somebody else? I mean, I don't understand, I don't buy the story that, I mean, that
And those
all
are all
that
good
is
points, yes,
water.
sir, yes.
And then all I do is tell you, oh, you got the wrong number, call this other.
It is fair.
I don't like $1,000, so.
Why not just put the other together?
I mean, so the owner of the property is not complaining, and the buyer of the land is not complaining.
Yeah,
It is a neighbor that's complaining
because the sign was up in the
because the sign was up.
adjacent lot for several weeks.
Maybe I don't want it.
Maybe.
They should have called the number then. You know, I mean, you apparently saw it, so.
I make a motion, we fine $250.
Second.
So Commissioner Dow makes a motion to reduce the civil penalty from $1,000 to $250. Good, seconded by Commissioner Bagley. Any further discussion?
Yes, I feel like I have this question every time this comes up. If it's someone that's unlicensed,
Mhm.
and we assess a civil penalty,
Mhm.
how, like, what's the motivation for them to pay the civil penalty? How do we collect that civil penalty?
If we have a hearing and we prevail on the hearing, then they are sent a consent order, just like they would if we recommended civil penalty. But they are sent a consent order, or the order ordering them to pay the civil penalty. If they do not do that, then it goes over to the Attorney General's office, and the Attorney General moves forward with the collection process.
So I would caution against not assessing civil penalties just because we don't think we'll collect for it, because the civil penalty is being assessed for the conduct
Mhm.
of unlicensed activity.
Yeah, I'm just curious if the person has any motivation to do something.
Well, I mean, unless they like dealing with the Attorney General or collection agency, I guess they dispose of.
In your judgment of the court, you will award into liens and garnishments and all that sorts of things. So there is an incentive to
Well, because
comply.
you put a for sale sign in your phone number.
Anybody's yard.
And that's your attorney, buddy, you gotta find it back.
Yeah.
So we have a motion, any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. Any opposed?
No.
And the motion passes by a motion of 8 yes and 1 no, Commissioner Torment voting no. That was case number 14. On to 19, which I get to take a break. That case 19 was Jones, I think.
It was. Tell us about it.
No, this is your case. You tell us about it.
Not you.
Yes, ma'am. Let me get back to the case number, yes, ma'am. The complainants were attempting to purchase a property that the respondent was the owner and seller of the property. The complainants are alleging that the respondent knew that there were existing environmental issues that would have to be addressed, and they did not disclose those issues. The complainant has provided proof that Tennessee Department of Environment and Conservation had mailed the respondent notice of those issues, and that they had called the complainant said the respondent they had called, all because they were the sole owner of the property, that they did not disclose these issues, and therefore that they didn't act with, well, reasonable skill and care. I probably should have said with honesty and good faith for all parties. The respondent acknowledged that they were the sole owner of the property, and did say TDEC contacted us, but stated that TDEC talked to their spouse, not them, and that they did not know about these issues until just shortly before they were supposed to close, and that as soon as they did learn about them, that they immediately let the complainants know. The communications between TDEC and allegedly the respondent took place at least a couple of months before that, however, is what TDEC has documentation of. My recommendation, I would amend to a $500 civil penalty for failure to act in honesty and good faith with all parties.
It concerned me when the respondent blamed the oversight on a busy sports season.
Yes, ma'am.
Those can be hectic.
Yeah, I know, I was like, that can be an excuse for a lot of things.
Especially during playoffs.
Well, their children played travel ball, and so they were apparently traveling a lot with one or more children, and again, yes, blamed their oversight on that.
What were the environmental issues?
They were.
You feel like it affects the value of the land or the property?
The complainant certainly did, but let me. I think it was more that they were gonna have to spend money to clean up the property, not necessarily that it would, if that makes sense.
It's not a Superfund site, right?
Yeah, no.
Okay.
I'm gonna make a motion for $1,000 civil penalty for failure to act with reasonable skill and care in providing services to all parties.
Second.
I have a motion by Commissioner Bagley to offer a civil penalty of $1,000 for failure to exercise reasonable skill and care and to do honestly and good faith for case number 19. Made by Commissioner Bagley, seconded by Commissioner Moffitt. Any further discussion? Hearing none, all those in favor of the motion, say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 26.
It's open. I don't need to know the environmental issues.
It's storage tanks, underground storage tanks, that may or may not have already been implemented.
So this was, okay, so this is unlicensed activity.
Yes, sir.
This one I kind of, my mood was kind of offer them a clock to finish the licensing process or assess the fine. And the reason why is because they did go through the effort to comply, to try to comply with the local permits and all that kind of stuff. They just missed this step. It's a pretty big step.
But are they licensed?
Yeah.
Are they licensed? Are they licensed now?
You know, so.
Yeah, are they-
To Commissioner Smith's question, when I drafted the legal report, they were not, I haven't had a chance to check on this, and we can see if they are now. Ms. Matlock's suggestion was to assess a $1,000 civil penalty for unlicensed activity unless they are licensed by a certain date that the commission wishes, and then we could reduce it to 500 or some other amount, payable amount lower.
Yeah, because the conduct was still unlicensed activity, but
Right.
what do you think, Commissioner Smith?
I agree with that.
You like that?
Yes, I like that. And licensed by the end of, we are,
November?
October,
yeah,
we are in
I'm just trying to think how quick they are. I'm gonna say by the end of the year. Is that too long?
No.
I She don't rule.
It's 2 months.
She don't rule.
I'm just saying, like,
Well, let me
I
change
feel
it
like
to
we
be.
want it to be pretty quick, right? Or do we still want them out since the deals?
Okay, let's say, but are they in the process? We don't know how far in the process
We've
they are.
had many people say they're in the process and actually never follow through.
All right, so let's change this,
30 days.
November 15th,
That's less than 30 days.
Yeah, the 17th.
17th works for me.
So if I could try to state the motion. The motion by Commissioner Smith is to offer this respondent the opportunity to complete the licensing process by November 17th, or pay a $500 civil penalty for unlicensed activity, or $1,000.
$1,000 if it's not, but if they're licensed by the 15th, 17th, then it could be reduced to $500.
Okay. So this respondent will get an opportunity to finish the licensing process by November 17th, 2024, and pay a $500 civil penalty. And if it's not completed by November 17th, then a $1,000 civil penalty. Does that sound right?
Yes.
Okay, that was made by Commissioner Smith, seconded by Commissioner Moffett. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 29 was discussed. Counsel?
Yes, sir. 29 and 30.
29 and 30 are related?
Yes, sir.
Okay.
The complainant was a is a property owner that contracted with the respondent to manage their rental unit. The unit was rented to the tenant, or leased to the tenant in June of 2023. The respondent, on behalf of the complainant, collected a security deposit, and the respondent also collected from the complainant a $500 deposit for any repairs that may come up, in addition to the first month's rent from the tenant. At the end of the tenant's lease, they moved out, requested their security deposit back. In the meantime, the complainant had also terminated their agreement with the respondent and wanted an accounting of and the return of any deposit to the repair deposit that they had made. Essentially, the respondent then ghosted both the complainant and the tenant. The tenant never received their security deposit back. The complainant did not receive their repair deposit back. They moved forward, or told respondent they were going to move forward with any civil action that they could. That got respondent's attention for very briefly, and they said, oh, okay, essentially the check is in the mail. That check never appeared, and the complainant eventually paid the tenant the security deposit back out of their own funds, and has, again, continued to ask the respondent, where are you, what are you doing, why haven't you responded? And once that email went out that said the check is in the mail, the respondent again has just failed to communicate at all with the complainant.
So you sent when you tried to serve a process to this respondent, you sent it to the address on file, I'm guessing?
We sent because there was a complaint against both the individual and the firm. Both complaints went to the address that the licensee is required to provide to the commission, and both of them came back undeliverable, or I think one came back unclaimed, maybe both undeliverable. But they have not responded now to the complainant, and they've also ghosted the commission. Yes, sir.
And we are under the belief that they're still operating?
Yes, sir.
Still open for business?
Their license is currently active, yes, sir.
And expires next August.
Yes, sir.
So, seems to be, I mean, obviously failure to respond to the commission is a violation. But if they're not responding to us now, they may not respond to us ever.
Well, if he tries to renew his license in August,
Right.
and they're thinking 1,000 for not responding, 1,000 for lack of school care, honest dealings. I mean,
There's also the failure to timely account for trust fund deposits,
Yes.
which is the most, I think, basic responsibility of those brokers to safehold someone else's money.
So,
So you combine your 29 and 30.
No, it's 229.
well, I mean, they're related, so I would like to dispose of them at the same time.
Well, one of them's for the individual.
Who wants to confirm?
Yeah. The firm, I think, should get $1,000 for not responding. If we're gonna talk about 30. Yeah.
Well, and it just, I mean, I know we talked about the dollar amount, but also the full spectrum of our sanctions is available all the way up to revocation, if you think that's severe enough. Of the violation that you would want to do that. But they got a pretty good trifecta going on.
I can't start with the civil penalty.
Question. So when you say ghosted, what do you mean by that? Just fail, not responding at all?
Not responding to emails, texts, phone calls.
So did you deliver a return receipt requested notice to the address?
Once they've not responded within 10 days, then the letter that goes out and says you have a past due response, I believe, is sent certified mail.
And so that was returned to?
You all can also request an audit. You all can also request an audit, especially since trust funds are very important, and this person is a managing broker.
How intrusive can the audit
I know.
Well, and I'm saying, is it like a cursory audit, or is there a level where they go and they're more scrutinized?
It's not forensics accounting, but we do verify that the funds in the escrow and trust accounts are being used properly. And that's the purpose of a TREC audit, is to ensure those funds are there for intended purposes and not used as an operating account.
What was the 22?
And we can also go back up to 3 years as well.
What was the 22 letter of warning for?
Ms. Matlock's going to bring that up. I appreciate it.
We have the beginning of a motion, and if I can just restate the conversation so far, there was a $1,000 civil penalty for failure to exercise reasonable skill and care, another $1,000 for failure to deal honestly and fairly with all parties, and another $1,000 for failure to appropriately handle trust funds. Oh, no, $1,000, you're right, not the honestly and fairly, it's $1,000 for failure to respond. And then $1,000 for the failure to handle trust funds properly. So
You're tracking 3.
we're tracking for again.
And Ms. Matlock again has indicated earlier in the past meetings that usually if we don't have a respondent respond, we just move forward with a single civil penalty for failure to respond. In this case, I would be very open to the rest of it only because this complainant has been very detailed and has extensive records and has been in contact with me several times. And so I feel confident that I could move forward on those others if the commission so wishes.
When does the license expire?
August of 2025.
Is the complainant suing the respondent independently of this?
They have been advised that we cannot get restitution for them. We can only assess civil penalties, and so any other civil remedies that they may want to explore, they are certainly open to do so.
So right now, they're out of pocket $1,650, right?
They're out of pocket $1,650 plus the $500 repair deposit that they also.
So $2,100, they're out of pocket, no fault of their own, correct?
Correct.
So if we fine them, we get the money they don't. The only way for them to get money is suing the
Correct.
broker.
We do not have the authority to get restitution for a complainant, i.e. or a victim. The civil penalties are to discourage activity, not to enrich or put the complainant back into the same position they were. That's what the civil lawsuit is.
Correct. That's my point is, they don't think that they have to get their money, they have to go sue this person, correct?
Yes, sir, I know that.
Yes.
Yes, sir.
Okay, and they know that.
Yes, sir.
I'd like to make a motion.
Commissioner Thorpe.
I make a motion that we assess $1,000 civil penalty for failure to use reasonable care, $1,000 civil penalty for failure to respond, and $1,000 civil penalty for whatever the wording is about managing trust funds. And can we also add an audit to that? And request a track audit?
Second.
So Commissioner Thorpe makes the motion to assess $1,000 civil penalty each for failure to exercise reasonable skill and care, to respond to TREC, and to failure to properly account for trust funds. In addition, she requests an audit of this firm's records. And have a second by Commissioner Ferris. Any further discussion?
Yes.
Yes.
Commissioner Gwynn?
I think we ought to look at revocation myself. I mean, they've kept $2,000 that wasn't their money. And we fined them 3, so, you know, they basically, if they paid it, they still have their license. And they're only out of pocket $1,000 for doing all this, which is not my way of doing. I would support suspension or revocation or whatever, something stronger than money.
I agree.
Okay, Commissioner Gahn?
So if we can't find them, how do we serve all this? How's that happen?
That would be done during a hearing. Again, the licensees are required to provide us their appropriate and up to date and current addresses. I would show that we have made every effort to serve them and move forward with the default hearing if necessary. And assuming that we prevailed, part of the order would be that I would ask for a revocation. So if they were found to be after a revocation to still be operating again, that would be the Attorney General that would go after them. And as opposed to a collection process, it would be much more robust in a cease and desist sort of way.
Okay, so the motion right now is to assess the civil penalties. Is there any further discussion on that? Commissioner Smith?
Yes, I have one question. And it also included an audit, correct?
Yes.
So an audit will be done within a period of time? Can we admit that audit is requested within 30 days?
Director Baker, would that be possible?
And one more question on that. Should the audit determine that there are issues, then that audit comes back to us again, is that correct?
If there are issues, then there will be additional complaints opened administratively as a result of those issues. Yes, ma'am.
Okay. And if those issues were strong enough, then that's when we could actually revoke the license.
Yes, ma'am.
If we did do something else, is that correct?
Correct.
Right. If we skip the civil penalty, as Commissioner Gwynn suggests, and decide to revoke, then we can skip all that too. But
Just as a additional information, this managing broker is a firm of one.
Correct.
So if there was,
That's the problem.
if there was a revocation, it would not impact other licensees in the firm.
Could there be an audit if the license is revoked today? And is that even?
How are we gonna audit somebody who doesn't respond? I mean, audit just involves cooperation to some degree. And we're
So-
getting no cooperation now.
If an audit is done and the person doesn't contact our auditor, then we open up a administrative complaint. And in the past, I think in the past 6 months, you all have received, or have issued a civil penalty for, not, responding. So that's typically what happens. I think we've only had one since we've been doing audits. People have been very forthcoming with the information.
I don't think this guy's forthcoming with anything.
Commissioner Moffitt, I'm sorry.
I said he's not forthcoming with anything.
That appears to be the case.
Affect his license.
So I found a letter of warning from 2022, and it's related to, so the complainant filed was running a business for realtors, including inspections and appraisals. And the complaint was lodged over a check the respondent gave to the complainant for services that was returned for insufficient funds, and then they filed a police report. However, the respondent stated they were unaware of the allegations or the police report and included a copy of the check in their email, and it appears that it was a good check. So there was a police report made, there was no conviction related to it. So the commission issued a a letter of warning related to, I don't know, this one says reasonable skill and care, but the actual letter of warning cites B12, which is the 312B12, which lists all of the enumerated offenses for which an individual could be disciplined for.
Okay, I have one more question.
Go ahead.
I know audits have typically been, you receive the letter and then email your information back. Can the auditor actually physically go to this location, or is that?
That is a great question. We are allowed to, yes. We have not done so. We've been doing desk and virtual audits.
Right.
We are somewhat short-staffed, so we can do that within the next 30 days. Maybe it's a bit difficult to, where is the, oh,
Investigator would do that?
yeah, that's what we consider an investigator, yes.
So we could change the wording on the audit to be an in-person audit.
Yes, our auditor would need to go there, but evidently we consider an investigator. We'll coordinate that with our investigations team.
And that could actually be done within 30 days.
So what we would do is send an investigator to go and collect the files and then bring the files, back to the auditor at the office.
I see. So the investigator actually isn't auditing.
Correct.
They're picking up the file, bringing
Yes.
copies back.
Yes.
So again, I mean, I think Commissioner Quinn's point is salient, though, where an audit requires some level of cooperation, even if the investigator shows up.
Right, but failure to comply with an audit just goes back to any information, like anything that we would use in a hearing against the individual. So whether an individual complies with what we do or not can still be, dealt with in a hearing format.
I like the suggestion by Commissioner Quinn to just revoke the license, not create more work for our
Exactly.
our department.
This is my opinion, we're spinning our wheels.
Yeah.
Yep.
Totally.
So,
So if we revoke the license and then they finally respond, then what happens?
That's what we can do.
Can they ask for a formal hearing?
yes.
So they
Yes.
won't accept the revocation of their license?
If they don't accept the revocation, I'll go ahead and file a notice of hearing charges and move forward with the hearing. Yes, ma'am.
But the period of time between this meeting where the license is revoked and the hearing, they're unlicensed.
No, ma'am. It's a property right. You can't unilaterally do that. It needs to, you can recommend revocation,
Okay.
and then I'll seek to respond if I can find them. If not, I'll go ahead and file for a hearing. But it has to be through a hearing or agreement.
Okay. And if we have the hearing and they do not show up,
And summary judgment.
Then it can be a default judgment. Yes,
okay. Thank you. Thank you for clarifying the process.
Yes, ma'am.
So hold on, the motion that's under consideration right now is to assess civil penalties. So do we want to vote on that motion, or do you want to withdraw? All right, so we are going to go ahead and vote on the present motion, which is to assess the civil penalties, $1,000 for non-responding, $1,000 for reasonable skill and care, and $1,000 for mismanagement of trust fund.
Failure of timely account.
One favorite account for trust funds. And then the audit, deploying an investigator to collect the files and have that audit completed within 30 days. That's the current motion. All those in favor of the motion, please say aye. All opposed to the motion, say no.
No.
The chair, the noes have it, and that motion fails. On an 8, no, 1 aye.
Can I make a motion?
You can.
I make a motion, we revoke this licensee.
Is there a second?
Second.
Have a motion?
Point of clarification.
Go ahead.
We have two separate respondents. We have a light broker, and we have the firm. Is your motion to do?
So right now, I think we're focusing on case 29, and
So
then we'll do case 30 again.
if that license, this is a question. The license is revoked as the principal broker of a firm, does it not say, I mean, don't you have to have a license to have a real estate firm?
He could get it.
So is it,
You can get a broker.
He can get it.
Unless he is, he's probably the owner.
Well, it's Commissioner. I mean, Ms. Baker said it was a firm of one
I think
right
it
now.
needs to be voted on separately.
do we have to vote separately or
Yes.
no?
Vote separately, yes.
All right, so
So this is for
case
Ms.
29.
Ms. Mallon.
So is revocation based on the 3 things that we would normally assess the civil penalty for?
Commissioner Wynn?
Yes.
Okay, so this is for case 29.
And this is for, yes, the principal broker.
Case
Yes.
29. So we got a motion, got a seconded. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case 30,
I got a question though.
Commissioner Gahn.
So, when we have a hearing, are we allowed at that time to do civil penalties?
Yes.
Yes, sir. During the hearing, all options are open. Yes, sir.
Can we, on the firm, can we give the firm the civil penalty?
Yes. But I also think motion is the temper seems to be to revoke the firm license as well, but we'll see what the commissioners decide. Again, the full spectrum of our civil penalties is available as always. So on case number 30, fact set is the same.
Same motion.
Same motion. So Commissioner Gwynn is going to make the motion to revoke the firm license. In case number 30, is there a second? Seconded by Commissioner Moffitt. So the motion again is to revoke the license, the firm license for case number 30. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Aye. Any opposed? That motion carries unanimously. Thank you, everybody. So, Joan, you pulled case 31?
I did.
Okay. You're up.
I'm reading. Is this you, Kim?
Yes, ma'am.
Not a good time to have this.
I know, that's why I'm asking when I read this.
And
Okay,
that's why, okay, so in this case, we have 2 roommates who put down security deposit on a unit, and they are alleging that within 30 days of moving out, they have still not received their security deposit back. The respondent did not respond to the complaint. In this case, I recommended $1,000 for failure to respond within 10 days. As I mentioned a few moments ago, the complainant in that other case was very robust, a good word for it, very detailed. I have lots of documentation. In this case, I do not have that. I would like the respondent to respond. It would be an issue where it's been cleared up. I don't know, but I'm not given that opportunity to present that to you because the respondent didn't respond.
So any notices returned, not receivable, not,
No.
so as far as we know, they received it.
As far as we know, yes, sir.
So they did respond within 10 days and they got that certified mail piece and that came back to you
Yes, sir.
as received?
Yes, sir.
So since there's 2 complainants,
There were 2 roommates. One of the roommates is the one that filed the complaint.
so we can't do 1,000.
No, because there's only one complaint.
Because I'm doing Steve math. Steve's got $1,700 and he's only gonna get 1,000, so it's a pretty good return. Not a bad return.
Yeah.
So,
What are you suggesting, Joe?
we need to get to at least 1,700.
Are you gonna do Steve revoking?
I'll let Steve do that.
Well, I mean, again, you got the civil penalty for failure to respond and then you got the fairly to accurately account for, well, I mean, for money that doesn't belong to them, so.
That could be 2.
That'd be 2 violations if you wanted to do that.
Skill and care.
I mean, I guess you could by
Yeah,
the
I'll make
lecture.
I'll make a motion.
Go ahead.
$1,000 for skill and care, $1,000 for escrow duties, fiduciary responsibilities, and $1,000 for failure to respond.
Okay, so Commissioner Bailey makes the motion for $1,000 civil penalty for failure to respond, $1,000 for failure to exercise reasonable skill and care, and $1,000 to properly account for trust funds. Seconded by Commissioner Smith. Any further discussion? Hearing none, let's vote. All those in favor of the motion say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 34, Ms. Smith, it's you also.
It is, and I had a question in paragraph 2. The seller believed that the repair price reduction submitted by complaint was unreasonable, and their rejection was communicated to the complainant's agent. I'm curious how that was communicated.
Let me, whatever you see.
So you have, make a distinction between text and email versus there was signed rejection on the order.
Or did you say, you know, I'm at the coffee shop and I'm, you know, by the way,
Yeah.
rejected.
You wrote it on a cocktail napkin, kind of thing?
Wrote it on my
No.
Did they give it to their best friend and said, oh, will you tell so-and-so?
Your paperwork.
And I understand that, that it appears that it's already ended, that the earnest money was returned. But I'm just curious about,
It says the complainant signed the mutual release.
I get,
That's the amount. Like, if you sign something,
you're done.
it's afraid so.
I was just curious about
Yeah.
that.
I'm trying to, I have to wait on the computer, so if you give me patience.
That's,
I make a motion, we accept council's recommendation.
Second.
So council's recommendation is to dismiss.
Correct.
I'm good.
Okay, so Commissioner Gahn, you made a motion to accept council's recommendation, seconded by Commissioner Tucker. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 42, we'd like to discuss. Ariel, this is yours.
Okay, so this one, we're taking a quick summary. There's a lot kind of going on in the situation, but the respondent represented the complainant who was a buyer in the situation, and they entered a binding written agreement with all the parties. And after that, the respondent just stopped responding to the complaint. They had like a closing date and everything like that in the paperwork, but they didn't respond for months, and then months later, the complainant realized that the property that they had the agreement on was listed by a different agent, and they were entering another binding agreement. And it just turns out that the respondent never submitted the contract to the title company, and the complainant had reached out to the new agent who was selling the property, and they all agreed that their listing, or their contract took precedent over everything. Initially, the respondent didn't provide any kind of information, but when I requested additional information, just because of like the amount of people involved in the situation, they did respond, but they seemed to minimize it, saying it was like a one mistake after like being this like for like over 13 years. And the reason I wanted to bring it was just for potential like discipline. It seems like they're willing to give up their license. Right now, their license is in expired status. At the time, it was valid, as far as what it was valid. Very great, yes.
Did the complainant actually get the house eventually?
Yes, they eventually got the house, but it took a lot of effort to get it.
see a copy of the first contract?
Yes. All the
Signed
parties,
by everybody?
signed by everyone, they had a closing date. They signed it like November, the closing date was for February.
Question. So it says the respondent offered to retire their license as of this submission.
Yes, they seem like they don't care about being a real estate agent anymore. They are in a completely
So
different
are they
profession.
saying that, you know, if you don't find me, I'll do this, or I'm just willing to do it anyway, or
They're saying
what?
like, pretty much like, well, I'm doing something different now, so like, I don't care about this license, so I can give it up if I want to.
That's what they said? Well, I mean, that's always
Basically,
true.
that's, yeah.
That's always true, you're always
Yeah.
going to give the license if you want to.
Yeah, but essentially just pivoted.
I understand you're not wanting to pay the civil penalty, but.
To try to consolidate these dates a little bit. First paragraph says, on February 5th, they noticed that the same property was listed, okay?
Yes.
And then it says the complainant included a mutual release agreement that was requested on December the 1st. So they thought they had a contract, but they had signed a mutual release? I don't understand.
They're, like, since it's a lot of moving parts, so essentially, after they realized that the contract, I guess it wasn't submitted to the title company by their agent, was the respondent, they hired the new agent that was actually listing the property the second time.
And they said that the release wasn't signed.
Yeah, so they requested that it be signed by the respondent, because they weren't responding to,
He
they
clearly
were
doesn't care about his license
at all.
anymore, so.
Yeah, it's like two separate agents involved in the situation, and then two buyers and the response. It's a lot of people.
So the agent that's willing to give up their license is the agent number one.
Yes, it's a respondent, the one who was representing the plaintiff originally.
Not give it up, just retire,
I'm sorry.
so they could come back pretty easy.
I think that just months like not responding, the documents I saw, like, conversations from asking about what's happening, no response. The respondent didn't seem to like argue against that, they were just like, I made a mistake of like not following through.
So unless we present something and then they want to reactivate their license, then there's no way for us to flag that.
I think probably flag them, but it seems like just excessive, it was like months of just not responding, I don't think that they like care about their client at all, I don't think they, when they're supposed to care, they also didn't respond initially, had to like, go to 10 days, but, or it's that type of thing, just like, spoken it, like, voluntarily, I didn't know like what you guys.
This reminds me of last month's case, when the California person thought it was gonna matter or something, and it mattered.
Didn't matter.
In here somewhere.
Virginia, yeah.
Yeah. It was like 10 years ago, never gonna matter, and then
Yeah.
it came big.
Yeah, they did.
I think we need to do something, whether it's a letter or whatever it is. Otherwise, when they decide that, you know, I made a mistake, I want to do it again, then they just come back and are acting.
I'd love a motion.
And why not? About the revocation.
Ooh, no.
Steve Quinn. Where's his head again?
East Tennessee doesn't mess around.
We're gonna move to that. Okay. Commissioners, the floor is open for a motion.
I've got a question.
Go ahead.
If he or she wants to renew their license, and they pay their money to renew their license, can we say, we're not accepting the money, and we don't want to renew your license? We can't say that, right? It's not a two-way street, it's a one-way street.
It's a property.
Hmm?
The governor would not like you.
No,
License is a property right. So
It's a
that's
right.
Yes.
Yeah,
That's what it
I
has to
think
be
we need to have
process
something
to
on
take
file.
So we can't say we're not gonna renew your license.
I think we need something on
Unless you're-
file.
You can
So
flag
that-
it, right?
What do you mean?
We used to be able to flag it.
Well, yeah, that would be closing flag though. I don't think we
We
want to close.
flag it, meaning what?
They come
Yeah.
back.
What do you
If
want
they
to
came
achieve
to-
from the flag?
If they came back for something,
Yes.
is what you would flag.
And we could application if they wanted to renew their license.
Which even if they retire at 16 hours a year, plus fees, right?
Every other year, every 2 years.
Every 2 years.
Floor is open for motions. Please,
Is
somebody.
there an education motion down there, Mike?
No, there was a suggestion of education. Nobody's made a motion.
I'm trying to think of what education we require them to take on top of the 16 hours that they would have.
I mean, I'd love a core course.
There's a new one coming
Yeah,
out
there's a
soon.
new one coming.
And I would recommend that they take a core course
Okay.
on top of any other education that's required to renew their license.
So,
And the core would be with that,
well, counts towards CE.
with that, not counselor.
And just to clarify, is this only if he or she wants to renew? Because right at the moment, they are not interested in their license.
I mean, this,
Just at this moment.
this complainant could have missed out on this property, affecting any number of things.
At this moment, the license expired, right?
Right now, they're in expired grace, license expired 10/13. Okay, a couple days ago. But right now, they're in a grace period, but they did not seem interested in continuing, but if they chose to and they want to renew it, or you think like add the education then,
Again, if they're wanting to not do this and they're not carrying out the license, I don't think we need to create more work on our end to flag and expire and grace and da-da-da-da.
But what if they don't mean it? What if they're just saying that they're gonna, and
I
they're
just-
gonna let this go,
Oh,
and then
okay.
they're gonna not retire their license?
That's what I mean, that's why I'm thinking just revoke the license. That's my point.
Anyone wants to make a motion?
I'll make a motion that we revoke their license.
I have a motion by Commissioner Corbett to revoke this license. Is there a second? Motion by Commissioner Corbett to revoke this license, seconded by Commissioner Smith. Any further discussion?
Why are we doing that? What's the provision, statutory provision?
Based upon all these things. Council in their,
Because that's what you do
yeah, council in the narrative brought up, code 6213-403, 6213-404, paragraph 3, part A, sub 3, and 6213-404, paragraph 3, part A, sub 4, respectively.
It's in the
It's
law.
right
It's in
there.
the-
Oh. I'm like, goodness.
Y'all just couldn't let me take credit.
I think if council hasn't, if the council did not share any kind of narrative about the respondent demonstrating a disinterest in having their license and willing to retire it, I'm not really selling real estate.
Yeah.
If that weren't a part of this, I would be saying, hey, let's find this respondent for these failures.
So you think he'll accept the offer and the consent order? You think so?
If he doesn't, then we'll just still fine him, or them, or her. But,
That's a hearing then at that point.
right,
Okay.
but,
Okay.
yeah.
No fussing when that hearing comes up though.
When it's due, day two. When it's day two.
They didn't ask for it.
Okay? So that's the motion is to revoke. Any further discussion? Hearing none, let's vote. All those in favor of the motion say aye.
Aye.
Any opposed?
Yes. No.
You're opposed or you're not?
Opposed.
So that motion carries on 8 aye, 1 no vote. Commissioner Bagley voting no. That's case number 42.
And I would like to open up
Make a motion to,
an administrative complaint against the broker.
so we have a motion to administratively open a complaint against the broker for this respondent.
This is for 42, correct?
Case number 42.
Okay.
Is there a second?
Second.
So I have a motion by Commissioner Bagley to administratively open a case against the principal broker in case number 42, seconded by Commissioner Smith. Commissioner Bagley, do you have statutes in mind that you want, the same ones the council recommended?
To,
We can just open a complaint,
We don't need
It's just a
statute?
complaint.
Okay, so that is the motion.
Reasonable skill or failure to
least make him aware of this and, or her, and then also, you know, just understand that he may need to have a little class with the office. But hey,
Okay,
So Bagley Smith.
right, so we're ready to vote. Any further discussion on the motion to open this complaint? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. We are on to case 44, if everybody concurs. Commissioner Smith, that is you.
It is. I had a question where it said, do you want to do your
Sure.
narrative first?
So in this case, the complainant stated that the respondent had come up with $7,500 that they had agreed upon in lieu of repairs. And the respondent basically said that the complainant wanted a check after the agreement. So it's kind of a miscommunication on how that $7,500 is going to get to them. It was supposed to be a credit versus a just random check being issued to them.
But then it goes on and says, the seller to provide the buyer with $7,500 in lieu of repairs. And I want to know how they plan to give them that money.
They said it was supposed to be a credit.
It was a credit.
Is there,
Credit toward
I think like towards
versus
the,
price,
and probably like towards the price,
but you have.
but they didn't say specifically, like that's just how like they had written.
so is that in a contract, or is that just?
The quoted language where it says seller to provide buyer with $7,500 in lieu of repairs, provide a repair proposal per home inspection. That was the exact language.
In the contract, yes, in the purchase and sale agreement?
That's how it was listed.
It was in the purchase and sale agreement?
That's how that was listed in the,
In the repair amendment?
like in, it was in the, it was like an amendment.
To the
To the
contract
contract.
or to the repair proposal?
It was an amendment to the contract saying that in lieu of repairing any of the multiple things, we're going to give you $7,500 in credit.
Seller was going to give the buyer $7,500 in credit. Do you
Yes.
know how that was going to be given?
There's no like specifics about it being credit off of like a purchase price, but it
That's
seems
a-
like the parties were just misunderstanding on how.
That's the
They
red
want
flag
it.
for us,
So
is how did they get the money?
it was terminated.
They terminated the contract because they
Right.
just
They
couldn't
didn't
agree.
get it.
Mm.
Okay, although they didn't, and the contract was terminated, I just feel like that person that was doing that amendment should have a little bit more education in writing that, how they're going to give money back or to someone.
Do you have a motion in mind, or?
What's that?
Still here.
Reasonable skill in here. What were you saying?
So that,
It says based on information provided, and tell me if you're thinking of something different than this.
Okay.
Based on the information provided, the parties signed a repair replacement agreement that states seller to provide buyer with $7,500 in lieu of repairs provided in repair proposal for home inspection.
But she just said it was on the contract too.
I'll confirm real quick, I can pull it out. But I know that.
But again, whoever was writing this, you just don't give money. You need to say where you, how you're getting that credit.
so,
Yeah, that is the argument.
So am I out of line as a commission to request verification or education for the person that's writing this
well, we don't,
amendment, or is this out of our wheelhouse?
well, we don't want them practicing law without a license. So we want to say that, hey,
And then there was the part about the respondent's firm didn't agree to release the complainant's earnest money unless they signed a document stating that the deal was terminated because the complainant couldn't secure financing. So is this earnest money still held by escrow holder?
but that
I think since it
was held by the time.
I don't think they have it anymore, just since the contract got terminated. I think from the complainant's perspective, there or I believe that the respondent just didn't have the money and that they were trying to.
Okay, let me back up to this other thing.
Well, if they give them credit, they don't need the money, as long as they don't owe more than the, so, you know. the net price, but, so, looks like the disagreement was the buyers wanted a personal check outside of the closing.
I agree, because that's in the paragraph above. The buyers wanted a personal check outside of closing.
Yes.
So council's recommendation was to dismiss. The commissioners have a different disposition that they want to suggest. Motion.
Indeed.
Did the complainant have an agent?
I believe it did, yes.
DJ, I guess the seller's saying, because you want to do something that we can't do, it's not a reason for me to give you your earnest money back, you know what I'm saying? You can't give a person money from close. So there's no reason for the deal to go bad. There's no reason for the deal to go bad. We've offered you the credit, or college prepays or whatever, but, you know, because you want us to do something we can't do, that doesn't terminate this contract. Is why I guess the earnest
Is
money
that
could
why
still
the
be in
deal was
limbo.
bad, is because they wanted the cash?
Yes.
Then it should
The complainant wanted the, like they wanted that personal check.
should have done that. Okay.
Floor is open for motion.
Make a motion to accept council's recommendation.
Second.
So motion by Commissioner Smith is to accept council's recommendation to dismiss, seconded by Commissioner Tucker. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 52, Joan?
Yes, I have a note, copies given to the seller, you want to give it there?
So Joan, I just want to say that case number 52 is related to case number 51, so you want different treatment for this one. Case number
Talk about
52.
51.
We didn't discuss 51. We accepted council's recommendation on 51.
Yes. Okay.
So,
Yeah, I just made a note of the same one. Would you give us the there?
Yeah, since they're kind of related, I'll just talk to them. I'm not going for it, not related. But it's, a respondent had two separate complaints against them, similar complaints, but different complainants. And this one, the issue is that the real estate agent was presenting themselves as an agent and a contractor, and then also an investor situation. Essentially, they had talked to the complainant and said that if they provide $50,000, they can get double that money in return. If they invest in this kind of flip property situation, they agreed, they didn't get the money that they thought they were, and they were sort of like being reinvested, so they gave them more money.
60,000.
And then, same thing happened, and now they're out of a lot of money, and they would like that back.
so council's recommendation was to assess a civil penalty for failure to respond
Yes.
and to refer this case to the Contractors Board and the Tennessee Securities Division.
Yes, so they involved in some kind of investment, I think.
What do you think, John?
I want to accept council's recommendation.
So you're going to say that's a motion to accept council's recommendation,
Yes.
seconded by Commissioner Moffitt. Any further discussion?
Yeah, I got a question. So this is an affiliate broker that got $110,000. It's not really responding?
Yeah, it seems like they were kind of like, like investment situation, but yes, I'm not sure what that money is if they didn't respond or like their exact involvement, but they have quite a few complaints about,
Taking somebody's money
yes,
and not giving them any back after 2 properties were sold?
yes. But this, like, that was a separate situation, but yes, they have different, and the one before that it was related to, it was also similar about like,
Should
they
this
were
person
running
have
out
a license?
no, it's really,
I mean, if I'm clear, this person takes 100 from just this, what we're reading, they're taking $110,000, sold both properties and not returned any money, right? And they're acting as a professional real estate person. I mean, they have a license. I mean, I'm
Do you know
missing
the
something.
properties were sold?
It's
I don't know much about the properties other than what the planning
It
says.
just sounds a lot like a Ponzi scheme that I am very
these are licensed.
Right.
They are licensed, and they have a, so
I mean,
I
who
love-
knows if the property was sold or
That's
not?
not what
It
this
sounds
says.
more like a Ponzi scheme. It says it was sold, but it's not.
yeah, I'm not sure if it's actually sold, but I think it's gonna based on their interaction, they're probably working up with the property.
And I'm not sure
Since there's
that's
something getting.
relevant to them being licensed.
Right, I think that's two totally different things. I think if this is a Ponzi scheme, that needs to go to the VA somewhere, but should they have a license if they're running a Ponzi scheme? I think absolutely.
I mean, anybody else?
That's just my own opinion. I don't
That's
know if
mine
they're
too.
running a
That's
Ponzi
mine too.
scheme, I'm just saying it
Whatever
sure
they're
sounds a
doing.
lot like
If
it.
they get convicted, they would have to give up their license, correct?
Is it a report to us? And then,
So,
But I mean, they could do this 3 or 4.
all right, so just to understand, is related to the previous case, case number 51. And in that case, we accepted council's recommendation. And Joan pulled case number 52. So are these 51 and 52 going against two separate licensees?
it's the same license.
Same licensee? Okay.
And there is an open motion.
There is an open motion, so
That we accept.
that we accept council's recommendation. So that motion might have to be voted on, and whatever the result is the result, or withdrawn before we can consider another motion. Go ahead, Commissioner Lee.
This respondent had communication with the department, or with the commission at all? I mean,
No, they just want, haven't responded at all.
I'll make a motion
Well,
to
hold on.
substitute motion.
Okay, substitute motion.
I'll make a substitute motion for revocation of this person's license.
All right, so we have a substitute motion to revoke the license made by Commissioner Bagley. Is there a second on the substitute motion?
Second.
Seconded by Commissioner Tucker.
And this is on number 52.
This is on number 52.
So they still have $1,000 civil penalty
They do.
and getting referred to collections for 51, and now for 52, we're going to go to the license, which we can do.
We can. Okay, so we're going to vote on a substitute motion.
And the reason why you were voting is because 213 through 13.
That's failure to respond.
Commissioner Bagley?
I'm doing, for skill and care, for failure to respond, for,
Throwing the whole book out.
acting as a professional realtor, I don't know what that is, but I mean, just,
Skill and care.
They're not a realtor, but they were.
they're a licensee, I'm sorry, I missed
So skill and care, and what was the other one?
Failure to respond.
it. Failure to respond.
Okay. So this is how this is going to work. We're going to vote on a substitute motion, and if that passes, then we dispose of this case. If it fails, the original motion to accept council's recommendation would be in order at that point. So we are voting on a substitute motion to revoke the license, this licensee's license for the reasons and the statute stated. Any questions about that? Hearing none, let's go ahead and vote. All those in favor of the substitute motion, say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously.
I'd like to make a motion that we open up an administrative complaint against the principal broker.
Second.
Motion by Commissioner Gahn to administratively open a complaint against the principal broker for failure to supervise.
Yes, sir.
Seconded by Commissioner Gwen. Any discussion on that motion? Hearing none, we're ready to vote. All those in favor of the motion?
Aye.
Any opposed? Hearing none, that motion carries unanimously. Commissioner Gwen, you pulled case 56.
Yes, only a question. No, I just want to know what the home inspector licensing program is.
It would just be, any home inspector that,
It's a regulatory board.
It is a regulatory board. So you're just turning it over to them? for
yes,
them to look at?
just based off the complaint, so essentially it was just that there was like mold and exposed like wires and spillage.
They would be the board of jurisdiction. They would be the board of jurisdiction.
Yes, they would be responsible for knowing.
So I'm good with the motion.
So your motion,
I'll make
and
the
Commissioner
motion.
Gwen, is council's recommendation?
Yes.
Commissioner Gwen makes a motion to accept council's recommendation to refer this matter on case number 56 to the home inspector board. Seconded by Commissioner Moffett. Any further discussion on that? All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously.
Sorry,
Thank you.
Commissioner, just to go back really quickly for W2, just for clarity. Are we also with referring it to the other boards, contractors and
In number
security?
50
And
in number
52.
51, we're referring it, we're assessing a penalty. 52,
Okay.
we refer.
There were two separate reports, so I just wanted to clarify for W1, I believe it was just the contractor board, and then 52 was contractors plus. Is that, okay, Commissioner?
You good?
I'm good.
Thank you, council. Thank you, staff. Next item on the agenda is commission discussion. Commissioner Baker, do we have anything for us?
Yes, I have 3 announcements.
Okay.
The first announcement, the next meeting will be in Nashville on November 13th. We will also have rulemaking hearings during the meetings in November and December. I want to thank again the kindness and hospitality of NETAR, especially Edith and Darlene, and President Michelle Davis, and also want to recognize 2 former Tennessee Realtor presidents, Joel McKinney and Randall Thomas. For those here for CE credit, first of all, thank you for coming, waking up early with us this morning, and thank you for coming to attend a TREC meeting. Lots of revocations today, so hopefully.
Offers.
Hopefully you guys have learned something, and I hope it was beneficial to your, I hope it was beneficial to you today and you guys learned something. Don't forget to sign up for E&O insurance if you use the state of Tennessee provided E&O insurance provider and Charities. That concludes my announcements.
And I'll just say one more thing. Also, we have a former commissioner in the room with us, Diane Hills. She's here. So thank you to her. Is there any other former commissioners that have been? All right, very good. I didn't want to leave anybody out. So thank you very much, Diane, for joining us and for your service.
And one last thing, it's great to see all 9 of you guys in East Tennessee. So excited to have a full forum with all 9 of you all. Thank you guys.
So, commissioners, anybody else want to say anything? Hearing none, is there a motion to adjourn? We are adjourned.
Thank you.